IP protection not give you?
Well, I'll just carry on with the patent example. And what it doesn't provide is the commitment, the resources, whether it's people, money, or other, to actually enforce. The obligation, or the right, if you will, is on the intellectual property holder to enforce their patent rights. No one else is going to do it for you. So you really have to think carefully in contemplating enforcement as to whether the size of the prize is big enough to warrant the investment and the burden. And certainly in the patent space, where you have your research and development team or your inventors, and you're taking them off of developing new products and generating revenue opportunities for you and putting them into an infringement action, there's really quite a cost associated with it.
What should these teams be thinking about as they bring on employees and contractors in regards to protecting their intellectual property and ensuring that they're buttoned up so that they don't end up at a time when they have few resources in a situation where they have to make the kind of choice that you're describing?
Well, when I hear that question, Camille, what I immediately think of is a common misperception that because someone is paying for the creation of what might be an intellectual property asset, that payment equals ownership. And we know that that's just not the case at all. For example, we'll talk about patents. And the default is that an employee owns the intellectual property, the inventions that they create, unless there's an express or an implied contract that provides otherwise. A great example of this is the Calgary Park Plus debacle that appeared a number of years ago, where some City of Calgary employees were involved in the creation of the automated parking system in Calgary, and they retained or attempted to retain the inventors' rights to that. I believe they even filed a couple of patent applications in their own name and not in the city's name. And so that really created a cost and put significant delay on the city's then vision to look to leverage that innovation and license it for some revenue. And if we look at copyright, we know that copyright is owned by the author. However, the author is not a defined term in the Copyright Act. So the default is that if the copyright is created by an employee in the course of performing their job, then that is owned by the employer. The rub here goes to working with contractors and consultants, and the default is that the contractor will own all intellectual property. So if you have a developer that's creating code for you, they actually own the intellectual property, the copyright in that code, and the moral rights, unless it's expressly assigned in writing by the contractor to the party that paid for the work. So the message here really is, number one, just because you pay for it doesn't mean you have ownership. And number two, it's best practice, and I would say essential, to ensure that you have ownership rights with all of the appropriate assignments in place, not only in the employment context, but with all of the contractors and subs that you have working with you.
So let's say you're the City of Calgary, or you're one of our ventures, and you run into one of these situations. You've got employees or a contractor that have violated an agreement, or a competitor has violated the agreement. What do you do to enforce, or what rights do you have to enforce your intellectual property rights if you've protected them appropriately?
Well, and really what we're talking about is, if we're talking about enforcement, we're talking about a legal solution to a business problem. And my preference is always to find a way to get the business teams to come together. Hopefully rational minds will prevail, and a business solution can be worked out where perhaps the lawyers come in and put the appropriate protections in place so that that can be implemented. With the appropriate contracts and the appropriate assignments in place, you really are put to the task of putting the other party on notice that they have overstepped their rights and are violating yours. And if you can't come to terms with that party, you're really stuck with going down to the courthouse and getting a third party that doesn't know you, doesn't know your business, and certainly doesn't know your intellectual property to decide the outcome of what your dispute may be and how the spoils are going to be split up. You know, if we go back to one of our previous conversations, which was around, you know, what are the remedies for patent infringement? Well, there's, you know, the equitable remedy of injunction to stop the infringer from infringing. There's the remedy of delivery up or destruction of the products. You can imagine that the court does not move as fast as business. You can imagine that, again, this is a distraction and this is a significant cost. So I would really encourage the ventures or the owners of the intellectual property to really know what intellectual property they have, know the value of it to the business strategy and its contribution to generating revenue or other competitive advantage, and in that context, making a rational decision as to what sort of effort they're going to put into enforcing it. There's always the flip side to not doing anything, in that you may in fact be telegraphing to the marketplace that you're not open for business, that anybody can do that. So that's really a huge caution. But there's also some legal principles at play that if you sit on your rights and don't enforce them, that it may preclude you or prevent you from enforcing them in the future. So lots of considerations, all of them, depending on the value or the contribution of the intellectual property to the business, all of them, you know, points that really should be considered right up front when the venture is really getting set up with its governance, setting its processes, strategies in place so that it's all, you know, really clear.
You know, I've seen situations where companies have done this extremely well and, you know, have ended up as a competitive strategy being taken to court to delay them raising funds and slow them down, and have been successful over time in winning. Companies that have had their IP stolen in China and have been able to hire the police and the detectives to sort it all out and have successful outcomes. So I think being buttoned up, if you're serious about your business, being buttoned up is vital as a business strategy. I think you've described some of the rationale extremely well.
Copyright is not an idea. Copyright is the tangible expression of an idea. So it's that tangible expression that is the intellectual property asset. As we said before, copyright arises upon creation. There's nothing that needs to be done to formalize the existence of that right or the ownership of that right. There is an opportunity in Canada to register your copyright. That, however, it does not tactically factor into your ability to enforce it. There may be strategic reasons and practical reasons that you should do that. If we compare that to the States, where you actually have to register your copyright in order to enforce it, we can see that if you're looking at the North American market for any copyright as part of your business, then you have to be aware of the copyright scheme in both jurisdictions, and they are different.
Trademarks. Can you tell us what a trademark is and give us some examples?
Well, sure. So a trademark is a word or group of words or image that identifies the party providing the services or the products as the source of those products or services in the mind of the consumer.